This is a presentation I've given before in about an hour time span, so I've cut out a lot of the content, so I'm going to fly through it and see how much we can get through in 30 minutes. So probably the most important thing that you need to know is what a pimp slap is, and it's different than a bitch slap. So a bitch slap is a powerful open-handed slap that uses the palm. The pimp slap is the same thing but uses the back of the hand, so it's critical that you know that to understand this presentation. It's required that I have a disclaimer, so here's my disclaimer. And here's my real disclaimer. To give this presentation, I have to dress the part. So I have the pimp cane, the pimp hat. Before I forget, I have some bling too. So if this presentation doesn't go well, at least I'll look the part.
Which one is this?
Oh, this slide's not supposed to be in here. Never mind that. Okay. So a little bit about myself. I've been in the information security field for about 12 years. I started off as a practitioner. I ran a couple of IT consultancies from 1999 to 2004. After that, I decided to switch things up, and I took an analyst position at a university where I learned a lot about organizations that have a very open environment and have 30,000 students inside the organization. After a couple years, I left and I went to work for a state agency. It was the Virginia Department of Corrections, where I learned a lot about physical security. I learned things like the reason that a corrections officer carries a key ring on their belt with a leather flap over it is so that the inmates cannot memorize what the notches look like on the keys. Because given unlimited time, you can do things that you can't do in other organizations. I also learned how you can make weapons out of paper and how you can smuggle cell phones via your anal cavity. So a lot of good stuff about physical security. Then I left and returned to the university in a CISO position in Virginia. Then I moved to Texas, and I'm also a CISO in Texas. So my last 3 roles have been as a Chief Information Security Officer. And I'm on Twitter as Steve Werby. And I've gone to 4 conferences in 4 weeks, and no one's recognized me because my avatar on Twitter, I have orange hair and a maroon beard. So just so you know, that's what I look like on Twitter. This is what I look like in real life. So I usually don't have a hat. Okay, I do have a few pet peeves related to data breaches. One, potential means possible. Potential does not mean actual. If you read data breach notification laws, they use the terms interchangeably. Exposed means that information was made accessible to an unauthorized person, and breach meant that that unauthorized person actually accessed the data. If you take a look at state and federal laws and other regulations, all these terms are used very interchangeably. Okay, so I'm going to give you some examples of some exposures that I have intimate knowledge about. One, and these are in no particular order, one involved a large number of laptops and desktop computers that were sent to a third-party provider to be sanitized, to have the data removed and have the hard drive destroyed. Those drives never actually made it to the vendor's facility. The driver took them to a flea market and sold them. And the computers that were sold were between 5 and 10 years old. An organization didn't know what kind of data was on those devices. The next exposure involved an operation that involved providing patient services to individuals with HIV and AIDS. There was an audit that was performed, and when the department became aware of the audit, the very next day all the computers in their office disappeared. There was no sign of forced entry. And the data that was allegedly on these computers included prescription information related to drugs that were only used by people with HIV or AIDS. The next exposure that I have knowledge of, these are all exposures that I was involved in some way with data breach notification or incident response. Involved a device, it was a computer, a low-end computer that was hooked up to a piece of equipment that took Scantron forms, which are paper forms that students fill little ovals in, to process them and send the grade information to the faculty members. Student workers took the computer home to use as a gaming system, and when that was investigated, he threw it in a dumpster, and claims he was unaware that it had confidential data on the device. There's a few other breaches I have listed there, but in the essence of time, I won't go into those, but I do have a question for you out of curiosity. Which of these data exposures do you think these organizations actually performed data breach notification for? And that's different than which of these made the law have said that they had to perform data breach notification for. Does anyone want to take a guess at how many?
0.
0, okay. Anyone else want to make a guess?
1.
1? Okay. More than 1, but it's less than 5. So the 2 listed in green were the ones that the organizations actually performed data breach notification for, which may not be the ones that were required by law to perform data breach notification for. Okay, so why do we even have data breach notification? It all really started in 2002 when California came up with the first state data breach notification law. And most of the state data breach notification laws in the United States are modeled on California's. Now, that law and most of the other laws in the United States relate to financial identity fraud, not other types of confidential data that were exposed. So why do they do this? Well, the perception is that breaches of electronic data involving PII were increasing. That may or may not be actually true. Let's take a look. So no one knows for sure that the quantity or frequency of these breaches actually increased. A lot of fraud actually involves formats of information other than electronic data, and most of these laws only pertain to electronic data, not data on paper or data in other formats. And there's a lot of other reasons that it's just not really clear if these things have increased. And in fact, most data breaches that occur do not get reported. Okay. So this really leads to a vicious cycle where we have more and better laws, which results in more reporting, more awareness within organizations and the media, which results in organizations having better security, which is good, which entails more breaches being discovered, and more better laws resulting from that. So it's a cyclical set of events. But when we really look at it, the rationale for why we even have these laws is twofold. One, to let the affected individuals know so that they can make informed decisions, and presumably so that organizations that have been involved in data breaches will improve their security so that they'll have less breaches in the future. Okay, so I'm not saying that it's not good to do data breach notification. There certainly are cases where it is valuable to let people know that their data was exposed. But if we look at it a little closer, there's a lot of types of harm for which there is no data breach notification. There is no law that I'm aware of that says if your data was exposed and the result could potentially be death or physical harm to you, you'll be notified. Most of these breach laws have to do with personally identifiable information that could be used for financial identity fraud, or in some cases, health information. So another type of harm would be embarrassment or humiliation. If your Facebook profile was exposed, you may have photos and other information in there that you would not want to have made public, but there's nothing that actually requires Facebook to notify you if that does occur. So here's some other types of categorizations of harm. This is sort of how I look at harm. Death's at the top, and I'm not saying that everything's in this particular order, but death, financial loss, financial identity fraud, and social types of harm are the categories I typically think of when I'm looking at whether it's important to notify affected individuals. Okay, so in the U.S., we don't just have state laws. There are some federal laws related to specific types of information. Just going to fly through those. There are 4 states right now that don't have any form of data breach notification for electronic data. Fortunately, there are 7 states that do have data breach notification laws for paper data, but that's a significant discrepancy between the 46 and the 7. Puerto Rico, Virgin Islands, DC, and New York City have data breach notification laws. There may be other localities that do as well. The point really here is there are a lot of different data breach notification laws, and as a Chief Information Security Officer, it's difficult to keep them straight, and they're always changing. Okay, here's the 4 that don't have a data breach notification law. Okay, there's the real sign for South Dakota. I also think the sign for New Mexico is kind of boring looking. I'm not really sure why they have peppers on there, but That's what they have. There's also data breach notification laws in some countries, not very many, but there's more countries that are considering establishing those laws. So when collectively I look at this, it really gives me a big giant headache. Because if there's a data breach, it's hard to figure out what laws I need to look at. And I'm going to tell you now what the components are of typical state data breach notification laws. They typically cover who the law applies to in terms of what organizations, what data is covered, what formats of data are covered. For example, is it paper data, is it electronic data, is data that's encrypted and covered, or is that exempted? What actually constitutes a breach? What are the obligations of the organization in terms of disclosure? Who do they have to notify? What information do they have to share? How do they have to do it? How quickly do they have to get those notifications out? What, if any, penalties are there if the organization does not adhere to the data breach notification law? And are there any exceptions? Okay, so using some coding language, the two vertical pipes, or clauses, this is what a typical state data breach notification law looks like. It talks about whether it's an organization or individual that is subject to the law, whether the breach is involved, whether the organization is doing business in a particular state, whether it maintains data of residents of that state, or whether there could be any harm to individuals in that particular state. So there's some overlap and complexities there. The laws typically look at whether a first name or first initial in conjunction with a last name and some type of financial information, account information, like a credit card number, debit card number, a PIN number, a bank account number, and a password are exposed. If that doesn't occur, if not all that occurs, in most states that's not considered a data breach that requires notification. Some states care whether the information is encrypted or not. So in some states, you can encrypt the data and you still have to perform notification. Other states, if you encrypt the data, you don't. But many of the states that allow you to be exempted for not doing, for doing encryption, they don't specify what type of encryption you have to do. How many bits it is, whether it's protected by a password or a key. Those kind of details don't find their ways into the laws, at least yet. And in some cases, if information is redacted, and redacted is not always defined, it doesn't require notification. So I think we've all seen examples of PDF files that are redacted by putting a black rectangle image over the top of the PDF, where you can simply do a copy and paste and see what's underneath. According to some of these laws, there would not have to be data breach notification even if the document was exposed in that way. Okay. I'm going to fly through some of this. And I'm going to put all of the slides online, so anything that we fly through you'll be able to see if you like. Okay. There's a lot of vague terms used, like without reasonable delay. That might mean something different to me than it does to you. In some cases, you can delay the notification if you're cooperating with law enforcement agencies due to pursuing a criminal matter. In other states, you can't. Okay, so what do you actually have to do? So usually you have to make some form of written notice. It's usually okay to send an email, but you may not always have email addresses. Depending on the volume of people you have to notify, you may be able to get away via law by just simply notifying state media and putting something up on the web. So there's all kinds of complexities in terms of how you do it. And if you have affected individuals in multiple states, it becomes a real nightmare because the laws conflict. And I'll describe a scenario later on that will reiterate how difficult that is. The laws also don't really go into a lot of detail about what kind of content you actually have to share. There are some non-compliance ramifications. They're not very significant and they're not very detailed. And in some states, you don't have to do the notification if you as an organization feel it's unlikely that the person's going to be affected. And you might even be in a particular industry or sector that does not require notification. Okay. All right, but there's more. There are some new developments that I think are positive. California actually recently passed an update to their law, so it's likely that most of the states are going to follow suit. So these are some of the things that California is requiring to be in place by January 2012. So they've noticed that the people that have received these notifications have not been able to interpret them, so they want better content. Texas is actually implementing a law that goes into effect in about a year that goes beyond the HITECH Act for health information protection and data breach notification. With the HITECH Act, if there's 499 people that were affected, you don't have to notify them. You have to notify a federal agency, but not the affected individuals. With the Texas law, even if one person is affected, those individuals have to be notified. Canada and the United States are considering a couple of national bills. Don't get all that excited because the United States has been considering national bills for a number of years. What I really like about the Canada bill is it goes way beyond financial identity fraud to also consider humiliation, death, physical harm, and other types of harm. Probably the most interesting thing about the U.S. data breach notification law that's being considered is the very bottom bullet, username plus password or code to obtain money, goods, or services. So the way I would interpret that is, if your Facebook password is compromised along with the username, they'd have to notify you. If your email provider expose your username and password, and it doesn't really make it clear whether the password has to be in plain text or in hash format, you'd have to be notified. So this is all being considered right now, and I think it's a really good development. Okay, so it's even more complex just because it's changing so often. All right, so I kind of look at data breach notification and whether we should have it and what the potential impact is like a Rubik's Cube, which if you're old enough is a toy that has a bunch of colors on it, and you move them around and try to get each side to have one single color on it. Does anyone not know what a Rubik's Cube is? Is there anyone that hasn't actually seen one? Okay, good. All right, so there was a Ponemon study about 5 years ago, and I don't think the data's really changed that much. And one of the findings in their study was, of people that they surveyed who'd been notified of a data breach that they were a victim of, only 3% of them actually said that they were a victim of identity fraud as a result. So if you think about that, that really means that 32 out of 33 times we're notifying people, and they're never going to become a victim of identity fraud. So it's kind of like the boy crying wolf. Okay.
Thank you for explaining your graphic.
Wolf Blitzer, in case you didn't get it.
Yeah.
All right. So it's interesting because I asked people lots of different questions. Would you want this? Would you want to be notified about this? Would you want to be notified about that? And they always tell me yes. And it's sort of an all-you-can-eat mentality. So I'm going to list some of the questions I asked people. And they always tell me they want to know the answers to these questions. They want to know if there's a murderer sitting next to them on the plane. Well, who wouldn't, right? But if you come up with dozens of questions, I think we'd all raise our hands, or a normal citizen would say, these are things I want to know about. But there's ramifications of being notified about all these types of things. There's a lot of information overload. It makes people afraid about everything. They never want to leave their house. They probably wouldn't even want to stay in their house. Is that really good for society? And I say no. And on top of that, I'm not saying it's not good to take precautions, but these are all things you should be aware of anyway. So like somebody in your neighborhood who has a DUI, you might tell your kids, be careful riding your bike down the street. They should be careful riding their bike down the street anyway. And just because there's somebody in your neighborhood that has a DUI doesn't mean somebody from outside the neighborhood with a DUI isn't going to come screaming down the street drunk. So I think really what's important is looking at this from a risk perspective. And there are things that people should be doing anyway. So one of the things people should be doing is they should be routinely looking at their credit reports, looking at their bank and credit account information, not just when they've been told that their information's been exposed. People should do that anyway. Okay, so as I mentioned, very few states actually look at, consider something a breach if it doesn't involve electronic data. 30% of breaches involve paper. There's also other forms of information sharing that could involve a breach. Me talking to you could be a breach. There are no state laws or federal laws that I'm aware of that involve anything other than paper and electronic data. So if we're going to have these kind of laws, let's include every single type of way that information can be shared. Doesn't matter if it's smoke signals. Doesn't matter if I put your social security number and your password on a hamburger and ketchup, right? if that got exposed to that guy in the back and it was your information, you wouldn't care that it wasn't on paper in computer format. Okay, so I advocate that we consider all these types of things as being in scope for a data breach notification. All right, so I mentioned I was going to mention a scenario. So these are the kind of scenarios I've had to deal with. So some data in an organization I worked in was exposed. People from different states were affected. Those states had different laws. Some of the information that was exposed, let's say, involved a name and social security numbers, and others involved a name and grades and a student ID number. Well, FERPA is the federal law for education records. It doesn't actually say you have to notify the affected individuals, by the way. But in the states that I've worked in, there have been laws that says that you have to notify individuals if their social security number is exposed. So in this particular type of breach, my organization could conceivably say, 22,000 of you I'm going to notify because your social security number and grades were exposed, and 17,000 of you I'm not going to notify because you have a student ID number. Well, it's really hard to pick and choose like that. You could also say, well, only 15 of you are from Alaska, and Alaska says we don't have to notify unless 500 or more people were affected. So we're not going to notify you. So when you found out your information was exposed, you say, why didn't you notify me? I'll just say, well, sorry, you live in Alaska, we didn't have to notify you. It doesn't make a whole lot of sense. And a lot of the laws are ambiguous. They're also overly burdensome for small organizations. And in some cases, there's inconsistencies and incompatibility. So one is the law enforcement agency. If you're working with a law enforcement agency, you can delay the notification. But if you have data from different states, people from different states, one state might say you can delay for law enforcement action, and another might say you can't. So who overrides who? These are questions that even attorneys have a difficult time addressing. Okay. In some cases, if you get notified, there's not anything you can do about it. If I told you that your social security number was exposed because the IRS had a bunch of documents that got thrown in the trash, you can't get a new social security number, even if it was exposed. You can't tell the IRS you're not going to do business with it. So what is the value in telling you that that was exposed? Oh, and by the way, every single one of you has had your social security number exposed at least once. So why do you really care if it's been exposed again? Okay. We also have to take into account the likelihood of impact. In some cases, people think the likelihoods that are shared are really inflated. So take this woman, she was young, she got in a shark attack and lost her arm. True story. 50 or 100 people per year get hurt or killed in shark attacks. Tens of millions go into the ocean each year, right? So there is a potential impact, but the likelihood is low. And in a lot of cases, that's true with data breaches. In some cases, the potential impact is very small. You might get a little boo-boo on your head. Big deal. Okay. All right. There aren't significant enough penalties right now, so a lot of organizations go through this kind of logic. This is a character from the movie Fight Club. And there was a scene where they talk about automobile accidents and how they decided not to do a recall. Organizations go through the same kind of decision-making process with data breaches. If it's going to be cheaper to get the fine than it is to do the breach notification, they may decide to just take the fine. If it's going to be cheaper just to ignore it than it is to apply the appropriate security controls, they may decide to do that. So without appropriate sanctions and fines, organizations may make decisions that society would not agree with. This is a stock chart. Does anyone know what stock chart this is? It has to do with a very major data breach from 4 or 5 years ago. TJ Maxx and Marshalls had millions of credit card and debit cards exposed. You can see that the stock took a pretty big dip, but if you remove that dip and just kind of drew a straight line, the price of the stock has been increasing pretty steadily. So my sense is that the public, the affected individuals, have a very short memory. So when you look at something like a Sony and they're talking about hundreds of millions of dollars of loss or potentially tens of billions of dollars of loss, I don't really buy it. I believe tens of millions or maybe 100 million or so just for all the notification they have to do. Their stock did die by like 60%. but I think we're talking a year or two from now, the stock might actually rebound. Now, they continue to get compromised too, so they do have some work cut out for them. Okay. I also find that many organizations, when they're dealing with a data breach, they get really excited. There is a radioactive isotope called iridium-192, has a half-life of about 70-something days. In my experience, a lot of organizations, that's about what their half-life is when dealing with a data breach. All right, there are some alternatives though. Some of these are pretty stupid. Okay, so one thing we can do is we just basically ignore everything and just play Angry Birds. We could find companies $100 billion, they're not going to have the money, so that's not going to be effective. We could do what Mark Zuckerberg wants to do and just give him all the data and make it public, and then everything will be exposed. Or I have an idea, and this is really just to get you thinking. I'm not saying this is the best plan. It's a little bit stupid actually, but it's really to get you thinking. So it's a fourfold plan, and I'm not going to read it, but here's the aspects I'm going to go into. This wraps up my presentation. There's things in the laws that we need to fix. We need to increase the scope so it covers other types of harm. It should cover all organizations, not just specific types of organizations. So for example, in Europe right now, or at least in some countries in Europe, there is data breach notification laws in place, but only for the telecom industry. Doesn't make a lot of sense. And I think data in all formats should be covered. Ambiguity should be reduced. We need to improve consistency. It is a real nightmare to deal with these laws when you're dealing with 46 different states' laws, different countries' laws. And so what I tend to advocate in my organizations is, let's just notify, because we don't have the time and expertise to ensure that we're able to review every single state's law and ensure that we're looking at a current copy of it. We're talking about thousands of pages of documents when you take all the federal and state laws into account. So in general, one stance you can take is just notify about everything. Everything that's a data type that could potentially actually cause risk. When we are going to notify, let's not be real general and vague about it, so the person reading the notification has no idea what actually happened, what you're going to do as an organization to protect them, and what they need to do to protect themselves. Little organizations, I feel, should be treated differently. It's overly burdensome for a mom and pop organization to have to go through all 50 state laws and figure out what to do. I advocate having a government agency that at least can provide them some guidance and support so they can say, help, what do I need to do? Okay. This is a very simplified version of one model that I'm advocating. I don't have time to go into full details, but I think it would be beneficial to consider a model whereby we look at a scoring system based on the type of harm, look at the likelihood that the data was actually accessed. Because a backup tape that TRICARE had exposed because it was stolen out of somebody's car 2 blocks from my house in San Antonio with 5 million people's medical information does not mean the data was accessed. It means somebody broke into the car to steal that radio and to steal some other device in the car and scooped up the tape too. So the likelihood it was accessed, well, until it was notified, until the entire media found out about it, and the person maybe found out it had some value, was probably pretty low. The likelihood that it will be misused is low. Somebody would actually have to get hold of that information, know how to access it, know that it has some value, want to be a bad person, and then find a way to monetize that. And we should also take into account the organization's ability to mitigate. So if it's a credit card that's exposed and your organization can issue you a new credit card and prevent any fraudulent charges from showing up on your account, it's not really important that you get notified. There's no real risk to you. So if we try a tiered approach, one way to do that would be to, based on that scoring system, allow organizations to have low-level risks, just track those breaches internally, make them available to a federal agency in case they need to find out whether that organization is doing due diligence, and at least notify their internal staff. In organizations, I found often the information security staff and maybe legal know about a breach, but none of the other thousands of people do. So they don't know what they need to do things better to protect their information. A second level would be to notify a national authority, and the national authority can decide whether it is something that requires notification or not. And then if it's a high enough risk, then I do feel it's important to notify the affected individuals. So one way to do that would be to notify them directly. Another way would be to have a national web-based system, which would have pros and cons, which would allow an individual to at least see, does an organization, let me look up an organization, see if it's had a breach recently. Let me look up my information and see if any organizations have had my information exposed. Because even if an organization tries to notify you, the email address or phone number or mailing address they might have for you may no longer be accurate. So they may have notified you, but you may have not received the notification. Okay. In my model, I have different ways that you can bump up tiers and apply different sanctions if people are not playing nicely. Right now, there's not really significant fines for failure to notify. You can see they range per breach, not per affected individual, from $2,500 to I think actually about $500,000. I think that's in Florida. So additional things, and I have only 4 more slides left, that I'd like to see done would be for Social Security number to be phased out for anything but used by the Social Security Administration, increased penalties for the actual theft and misuse. Here's some things that organizations can do to do things better. In Europe, it's a whole lot harder to misuse credit card information. Here's some things that individuals can do. They're culpable to a degree. Individuals can do a lot better job to ensure that their data doesn't result in a breach that requires notification. So, sorry I had to fly through some of it. If there's any questions, we don't have time for questions.
We're out for during the session, but so yeah, but you guys can get together after, of course.
So I can take questions outside. So I appreciate your time.